Thank you, Mr President. I rise to speak on this bill with some degree of concern, in fact quite some degree of concern. The bill seeks to amend the Police Powers Surveillance Devices Act 2006 to expand the way protected information, as defined under the Act, can be disclosed, utilised and published in specific ways. But the amendments can be seen at the most basic level as a reduction of protection provided in the Act in regards to privacy. And while that is not wrong in and of itself, it should only be done with a clear rationale and purpose and thorough consideration of all possible intended and unintended consequences. It's certainly not something that should be undertaken for convenience and without all consideration of appropriate checks and balances that might be required. Mr President, we recognise the necessity of treating state surveillance of citizens with the utmost rigour and accountability. For example, the second reading speech of the Listening Devices Bill, another surveillance-related bill, stated this: "It is the government's view that electronic surveillance is the greatest of all invasions of privacy." And it was further stated in that speech: "It is the government's strong view that the practice of surveillance is incompatible with freedom of expression, freedom of thought, and the important principles to which a free society must adhere." Those statements, Mr President, convey to us the gravity with which we should make in the first instance or amend legislation in this area that relates to surveillance of citizens. And Mr President, with that in mind, I believe this is an unnecessary bill seeking to facilitate a specific and poorly scoped review of a matter of significant seriousness relating to the conduct of the police and the adequate protection of privacy in Tasmania. In a simplistic and misguided attempt to allow the police-commissioned limited-scoped O'Farrell review to occur, we are being asked to make changes to the Police Powers Surveillance Devices Act 2006 which may have other unintended consequences. These are changes that have not been fully consulted or considered as part of a more comprehensive review of that Act, which, by the way, is long overdue and warranted given progress that is being made in a national context on these matters. There are questions hanging over the proposed amendments that we have here, including whether they will even achieve the intended result of facilitating the O'Farrell review. The amendments in this bill have not been drafted to include checks and balances that we see in some other jurisdictions which provide for similar statutory powers relating to protected information. And this is not a bill that should be passed in this place, certainly not without a great deal more explanation and answers provided for appropriately thorough consideration. It's more than we have had to date, Mr President. As background, this bill relates to the actions of Tasmania Police whilst undertaking an investigation into Solicitor Jeffrey Thompson, who at the time of being charged with pervert the course of justice offences in August 2017, was working on matters related to the Sue Neill-Fraser case. The actions taken by Tasmania Police in a surveillance operation relating to this matter have been identified as illegal, have significant implications in relation to breach of privacy and potentially legal professional privilege. This situation jeopardises public confidence in the administration of justice in this state, plain and simple. On the 16th of June 2017, police utilised a warrant under the Police Powers Surveillance Devices Act 2006, issued by a magistrate to tape a meeting in a visitors' meeting room in Risdon Prison between Mr Thompson and a potential witness. On the 8th of August 2017, Mr Thompson's home was the subject of a search warrant, and on the 16th of August he had charges laid against him. 5 years later, on the 8th of August 2022, after various court proceedings, the DPP decided not to pursue the charges against Mr Thompson. And after the Crown announced that it was not proceeding, Justice Brett of the Tasmanian Supreme Court released a decision on the 25th of August 2022. A number of concerning issues emerged after the decision of Justice Brett in the State of Tasmania versus Thompson, number 2, 2022, TASSC 55. The illegality of the behaviour had been previously determined in the State of Tasmania versus Thompson 2022 TASSC 53, which was 28th of March 2022. Justice Brett found that the warrant was invalid on its face due to a serious defect. In fact, that defect was that the wrong subsection of the Criminal Code was referred to in the application. But Justice Brett also expressed concern at the issuing that the issuing magistrate was not properly informed about the process of the operation and the likelihood of picking up other conversations not the subject of the warrant, including potentially legally privileged conversations. The outcome of the decision was that it came to light that Tasmania Police had a listening device and an optical surveillance device running in the visitors' room of Risdon Prison from the 15th of June to the 17th of August 2017, close to a 2-month period. And in that period of, just over 2 months period, the room was used by numerous people, including members of the legal profession meeting with their incarcerated clients. Not only did the two devices record continuously for a 2-month period, there was also the ability to monitor such conversations remotely in real time from an investigation room in the police station from a dedicated website. There were 10 police officers potentially involved in the operation, 5 in the investigation team and 5 in the technical services unit. Justice Brett only heard evidence from Constable Jago and Constable A from the TSU. He held that there was clearly potential for the possibility that other material had been accessed by authorities. That's in paragraph 30 of his findings. All material obtained under the invalid warrant was held to have been illegally obtained. Justice Brett, using his discretion under section 138 of the Evidence Act 2001, declined to admit the evidence primarily because of the importance of ensuring the protection of privacy in respect of unrelated and privileged conversations during covert surveillance. Such protection was fundamental to the integrity of and public confidence in the administration of criminal justice, he held. Paragraph 36. Mr President, understandably, there were calls for an inquiry into the Jeff Thompson surveillance matter when all this came to light, including by local lawyers and their representative bodies. The matter had received local and national media attention, including in legal circles. It is readily apparent that a comprehensive, independent inquiry was required to obtain answers to the myriad of questions that arise on this matter and restore public confidence. A comprehensive investigation was further warranted as this illegal surveillance activity and breach of privacy only came to light 5 years after it occurred. It did not come to light through legislated reporting and accountability mechanisms, but through a protracted legal proceeding against an individual, which was later dropped by the state, but not before inflicting a great deal of damage on that individual and his family. So an investigation of this matter should examine and question how effective are not only the mechanisms, policies and procedures in Tas Police itself, but how effective are the accountability and oversight mechanisms that apply in Tasmania. I note that then Commissioner Hine at the time stated that this whole matter was a technical breach of the legislation. Mr President, this is an inappropriate preempting of any investigation and its finding. It is a mischaracterisation of a series of police activities that involved the violation of a fundamental right to privacy of an unknown number of persons, including the likely recording of legally privileged conversations. I note that at the time Commissioner Hine stated he welcomed an independent examination of the matter and welcomed any opportunity to ensure transparency and accountability of the Tasmania Police. This would be delivered, Mr President, by a genuinely independent and comprehensive inquiry. However, neither the police nor the Minister chose to establish such an inquiry. Commissioner Hine announced on the 31st of August 2022 that there would be an independent review by former Solicitor General Michael O'Farrell SC to, and I quote, ensure that appropriate processes have been followed. Essentially, in response to identified illegal activities, failures of process and failures of oversight and disclosure mechanisms, Tasmania Police commissioned its own review with a limited scope of the terms of reference. Questions of perceived conflict of interest were also raised in relation to this Tas Police Commissioned proposed review, including by myself. In 2017, at the time of the breach of privacy by Tasmania Police with this illegal surveillance, Mr O'Farrell was in fact the Tasmania Solicitor General, and in that role was advising government agencies, including the Tasmania Police. And in fact, around that time, Mr O'Farrell is on the record in writing expressing his positive views of the capacity and processes of the Tasmania Police. It was less than a month after he had expressed that in writing that the warrant to bug Jeff Thompson in Risdon Prison was sought by police and the 2-month surveillance occurred. It remains my contention, Mr President, that this presents an unavoidable perception of a conflict of interest in the proposed review being undertaken by Mr O'Farrell. Other options were available and should have been chosen instead. Mr President, as further background, all of this has occurred in the broader context of a demonstrated culture of non-compliance by Tas Police with telecommunications data and surveillance records, which is made evident in Commonwealth Ombudsman's reports for over the past 5 years. This broader context only points more fervently to the need for a response to investigating the Thompson situation that is above reproach, one that represents the most rigorous approach we could put in place. And I contend that the proposed O'Farrell review falls far short of that. So with that background, Mr President, what this amendment bill is intending to do is worth considering. The amendment arose, or the proposal for this amendment bill arose when the government realised that the proposed limited scope O'Farrell review into the surveillance device issues arising from the Jeff Thompson matter required legislation in order for Mr O'Farrell to be provided with protected information as defined under the Act. I, in fact, wrote to the Premier on the 6th of October 2022 seeking assurances from him that what was proposed under the terms of reference for the O'Farrell review was lawful, as it appeared protected information was to be provided to him without authorisation under the Act. I believe that consideration had already occurred within the department and was being considered also at that time that I wrote. The provision of protected information to Mr O'Farrell under the current Act would have been an offence pursuant to section 33(1), I believe, of the Act. Under the current Act, as it stands, the O'Farrell review could not access material which is defined as protected information. The Tasmanian Government acknowledged that a legislative amendment was required and the review was delayed. The proposed amendments that we now have here in this bill are intended to enable the police-instigated O'Farrell review to occur legally. The proposed amendment allows the use or communication of protected information for the purposes of an inquiry, review or investigation, as authorised by the Commissioner. The amendment also allows, in plain terms, the Police Commissioner to authorise the publication of protected information in a report that might arise from such a review or investigation. That's in essence what we're looking at here. And presumably the amendment, Mr President, is intended to allow the provision of all relevant information to Mr O'Farrell to conduct the review as per the terms of reference that have been drafted and tabled. However, I believe that it is not the case that that's what these amendments may do. I am going to mention those terms of reference, though, that have been tabled, Mr President, because it's relevant here as we speak about matters going forward. As I believe there are also problems with the narrow scope of the terms of reference provided for the O'Farrell review. The public, I believe, in this matter would expect a comprehensive, independent investigation of all aspects. That is not what these terms of reference for the O'Farrell review provide. The term of reference are totally inadequate. They are essentially a desktop review. Under the term of reference, Mr O'Farrell SC is only required to examine all surveillance device warrants issued to TasPol which authorised installation and use of a surveillance device in a prison across the last 10 years, the information provided to the issuing officers in relevant applications, the adequacy of any conditions or limitations imposed by issuing officers, and compliance with conditions or limitations imposed by issuing officers. The nature of the documentation to be examined is therefore very limited and is also constrained by the requirement for approval from the Commissioner of Police to approve the release of whatever relevant information and then the subsequent publication of that information may give rise to. The documentation does not specifically include the actual recordings from the meeting room or any associated downloads of those recordings from the monitoring in the investigation room, for example, or documents such as investigative or technical services unit running sheets, visitor records from the prison, emails between investigators and technical services personnel, diary notes, all of which would point to the activities surrounding the surveillance that was undertaken across that 2-month period and help us understand the full implications that it may have, particularly on the matter of privacy. There's also, it would appear, no scope for the inquiry to investigate whether there was or was not compliance with the Act or with police policy and procedure or any disclosures to the inspection entity. There's no reference whatsoever in terms of reference to the critical Section 29 report, and I'll refer to that a bit more later, which is a report back to the issuing magistrate nor is there reference in these terms of reference necessarily to records which must have been kept relating to the destruction of materials gathered through surveillance, which is required under Section 38 of the Act. In fact, it doesn't relate to the Act. There's not a specific requirement that this is against the Act at all, Mr. President. Most importantly, the reviewer has not been asked to examine whether there has been any misconduct underlying the established unlawful behaviour by police, particularly the information contained in the Constable Jago affidavit. Misconduct would also include a breach of the Police Code of Conduct at Section 42 of the Police Service Act 2003. On a positive note, the review will also consider whether any specific measures are required to reduce the risk of capturing private conversations unrelated to the investigation which may be the subject to legal professional privilege. That task obviously requires finding out the totality of what occurred in the Thompson matter. And hence one would expect that all members of the investigation team and the technical services unit and their supervisors would be interviewed and the relevant policies and procedures examined. Nothing has been said so far to confirm that this would happen. Justice Brett stated that there was the possibility that additional recordings were made, that recordings were monitored or listened to, observed or overheard, downloaded or recorded in the investigation room in which there was real-time monitoring or otherwise kept or stored. That's all at paragraph 30 of his findings. And I'll quote this from that paragraph 30. No one else from either unit was called to give evidence, nor was any evidence presented to exclude the possibility that any other material had been accessed by authorities. I'm not suggesting for a moment that this did occur, but clearly there was that potential. However, the current review will not serve to identify all conversations which were in fact recorded. It will not identify, under the current terms of reference, all those who had meetings held during the time of the recordings which may have been covered by legal professional privilege, for example. The term of reference does not identify a process for alerting people that their rights may have been infringed. As a result, it will remain unknown what the police actually captured as a result of the recordings in the Thompson case, aside from the own assurances we have from the police themselves. In the absence of a full and transparent inquiry, we cannot be confident that there has not been improper use of any portion of those recordings or that there will not be improper use or inadvertent derivative use in investigations in the future. In order to determine whether there has been improper use of any portion of those recordings, an investigation should examine the full transcripts of the Thompson matter, the unredacted running sheets of the investigative team and the TSU, Technical Services Unit, diaries, emails and the critical Section 29 report by police back to the issuing magistrate. One further comment on the limitations of the scope of this review. Under the current terms of reference, there is nothing that would explore the compliance with and effectiveness of oversight mechanisms currently in place, nor will it cover any consideration of the interplay between two acts in this space, the Surveillance Devices Act and the Listening Devices Act. Under the current terms of reference, there will also not be examination of the sustained criticisms from the Commonwealth Ombudsman on compliance issues over recent years. It also appears that Mr O'Farrell is not provided with any powers or protections under current legislation or in the manner in which the review has been established. For example, the powers to interview and access relevant information other than what might be granted to him from the Commissioner. So, Mr President, I'll move on to some key issues now with the bill. And the first one I'm going to speak about was only brought to my attention relatively recently, and I haven't been able to satisfy myself that we have a clear answer on it. It relates to the question about whether material relating to the warrant in the Thompson matter, which was found to be invalid, and the material then found to be illegally obtained, whether that and the recordings themselves actually constitute or actually fit into the definition of protected information under the Act as it's currently there. So relevantly, in the Act, Section 32 includes the definition of protected information, which it says means A, any information obtained from the use of a surveillance device under a warrant, or B, any information relating to 1, the application for, the issue of, existence of or expiry of a warrant. So the illegal recordings in the Geoff Thompson matter were not obtained under a valid warrant, and it appears that they therefore do not constitute protected information as defined in Section 32 of the Act. There's an open question there, Mr President. Justice Brett, in the 2022 Thompson decision, found that there was a serious defect in the warrant and it was invalid on its face. The illegal recordings were not obtained under a valid warrant. All material obtained from the continuous recordings in the meeting room of the men's prison was therefore unlawfully obtained. There's no reference in the relevant Justice Brett decision to protected information. Justice Brett concluded at paragraph 37 that, and I quote, "The reality is that the invalidity of the warrant meant that the impugned evidence was obtained unlawfully." From the definition of protected information in the Act, I believe all of the recordings, including those recordings in the Thompson matter, were not obtained under a warrant and therefore could be potentially not considered protected information. And therefore this amendment won't actually apply to them. This problem has been clearly recognised by the Commonwealth. In Section 44 of the Surveillance Devices Act 2004 at the Commonwealth, their definition defines protected information as A, any information obtained from the use of a surveillance device under a warrant, or, and then I'm going to move down to D, which says any other information obtained by a law enforcement officer, 1, without the authority of a warrant. So they contemplate information obtained without the authority of a warrant in the Commonwealth Act, but we don't do that in our definition of protected information. That distinction hasn't been made. So again, I believe that adds weight to the idea that what we're talking about here in the Geoff Thompson matter is not material that can be defined as protected information. The equivalent Commonwealth definition therefore specifically includes information obtained without the authority of a warrant. The issue of protected information was considered in the context of an invalid warrant in various cases. Tasmania's legislation, though, has no such inclusion. If the recordings in the Thompson case do not constitute protected information, as defined in Section 32 of our Act, there's a fundamental problem with the proposed amendment to Section 33 of the Act if the intention is to allow Mr O'Farrell access to that material. It follows that any recordings made of the privileged conversations in the professional meeting room over the relevant 2-month period, not being protected information, do also not attract the specific protections of the Act. I note that this means all the recordings, not just those that were intended to be used in the prosecution of Mr Thompson, but all the recordings don't fit then into this category. Mr President, putting that aside, what if the Thompson recordings are protected information? If my suggested interpretation is incorrect and the illegal recordings from the Geoff Thompson matter are indeed protected information, then I think that presents us with a potentially even larger problem in our Act. If that were the case, and I'll just open the Act so I can be accurately referring to the section. If that were the case, in the Act, Section 33 4A, which reads this: 4. Protected information may be used, communicated or published for any of the following purposes. A. The investigation of a relevant offence within the meaning of this Act or a relevant offence within the meaning of a corresponding law. That means, Mr President, that if illegally obtained recordings, surveillance, were regarded as protected information, they could be used under this Act for purposes described in 33(4)A, and that would mean that Tasmania Police, without having to obtain specific authority from the Commissioner of Police, would be able to use those illegally obtained recordings and the contents thereof in the investigation of relevant offences, that being offences punishable by a maximum of 3 years or more. And whilst legally privileged material may not be able to be adduced into evidence in court, it could still be used to assist in investigations and subsequent prosecutions. Would we regard it as appropriate to use protected information if that information has been illegally obtained in the investigation and then subsequent prosecution of another matter altogether? That seems to be something problematic if we are to interpret illegally obtained material as protected information under this Act. We are saying you can illegally obtain material and then use it to help investigate and prosecute another matter altogether. I hardly think that would meet community expectation. I'm shuddered to think what the legal fraternity would make of that. Fundamentally, if it's intended to allow the provision of all relevant information to Mr O'Farrell for a comprehensive review, and if the recordings themselves and any downloading or copying of those recordings are not by definition protected information, then these amendments don't work. If we understand them that this illegally obtained evidence does in fact fit the definition of protected information, I think we're in trouble on another front in this Act, Mr President. These are unanswered questions. We do not have enough information about this at this time. So I would say that unless and until a different specific statutory amendment is made, any unlawfully obtained information in the Jeff Thompson surveillance matter cannot be used or examined for any oversight purposes without the potential for civil or criminal liability even. Again, this is a risk that I don't think we've fully contemplated here or had explained to us or investigated. Mr President, I'll move on to another issue. And in discussing this, I'm going to talk about whether a review into these matters could actually be done under the current Act without any alteration whatsoever, and no need for this bill with the amendments. And in discussing that, I'm going to accept the idea that the recordings and materials in the Thompson matter fit the definition of protected information. So we're assuming that as I make this discussion, that they are protected information. Essentially, Mr President, what I'm asking is, could we have had a review into these matters around the Jeff Thompson case and the surveillance that was undertaken in Risdon illegally? Could we have had that under our existing legislation under section 33(4)D? And again, for the purposes of clarity, section 33(4)D, so 4 being protected information may be used, communicated or published for any of the following purposes. D reads, as one of those purposes, an investigation of a complaint against or of the conduct of a public officer within the meaning of this Act or a public officer within the meaning of a corresponding law. That would seem to provide an opportunity to investigate these matters if we are contemplating it as an investigation of possibly into the conduct of police officers in this matter. When asked about this in the other place and in briefings that we have received, my understanding is the government's response to this is that no misconduct of a public officer has been alleged, and therefore we can't use section 33(4)D under the current Act. That's not my reading of the Act, and I think there's an open question there about whether there was absolutely no legislative change needed in order to pursue that. It's not clear how the government has ascertained whether any complaints in this matter have been lodged, for example, either with the police, with the Integrity Commission or with any other agency. Particularly given that, for example, I lodged a complaint with the Integrity Commission on this matter on the 12th of October last year. So there is things that can be pointed to. I would say here the Integrity Commission declined to take up the complaint that I made because it acknowledged that there was a review being held within police under the O'Farrell review, even though that review clearly is not about possible police misconduct, given its limited term of reference. One of the allegations I put into that complaint that I made was that Constable Jago did not exercise due care and diligence as required in the Police Code of Conduct in the preparation of his affidavit. Misconduct is defined very broadly in Section 4 of the Integrity Commission Act 2009, and it includes this at Section 4. Section 4A1, a breach of a code of conduct applicable to the public officer. And also in the Police Code of Conduct, Section 42 of the Police Service Act 2003, it states, 42, Code of Conduct 2, a police officer must act with care and diligence in the course of his or her duties in the police service. So I believe a case could be made there as the basis for an investigation around this conduct. Without preempting what the finding of that investigation may be, there's a case there that could be investigated around conduct. However, in response to my complaint, the Integrity Commission argued the matter was being adequately dealt with by Tasmania Police. In his letter date to me on the 25th of October, Mr Michael Easton, CEO of the Integrity Commission, stated that he was advised at the time by the then Commissioner Hine that any potential misconduct identified during the O'Farrell review would be investigated by police and notified to the Integrity Commission as part of the letter of understanding that exists between the two bodies. However, the scope of the O'Farrell review does not specifically include investigation of possible misconduct and is a largely desktop review. I don't believe that this would meet the community's expectations when it comes to a full and comprehensive investigation of whether police misconduct in fact occurred. The complaint was dismissed by the Integrity Commission under section, just for clarity, under section 36(1)(f), which means it was deemed to be not considered in the public interest for the Integrity Commission to investigate the matter. I think that that's a mistake. I think that that's not the Integrity Commission functioning as the community would expect. The Integrity Commission has no confidence, I think, should have no confidence necessarily, that the O'Farrell review will go anywhere near the issue of misconduct, and therefore the Integrity Commission should step into that space and can do so with an own motion if it so wished. Further, Mr President, moving on, but still on this same topic of whether we could capture this the effect of a review within the existing legislation without this bill. In relation to the government's assertion that no misconduct by a public officer has been alleged, there are also other comments in the public domain which point to concerns about police conduct in this matter. I do note Mr David Edwardson KC, who represented Jeff Thompson in the Supreme Court, saw fit to publicly comment on the matter once the charges had been discontinued. He commented on the Wrongful Convictions blog, which is run out of Sydney by journalist Andrew Urban, on the 8th of August 2022 as follows, and I quote, "Frank Miranda, my junior counsel, together with John Munro, instructing solicitor, and I, have been fighting this case now for some years. Finally, when the judgments are published, everyone will appreciate how misconceived this prosecution was and why the conduct of Taspol in the context of this case is so reprehensible. Every now and again there is a case which is so important, and this is one of them. Jeff Thompson was just trying to help fight Sunil Fraser's freedom. In return, his life and career was turned upside down by illegal conduct, the details of which will be published in due course. Today is a very important day, not just for Jeff Thompson." David Edwardson QC. This comment, Mr President, in the public domain, I think, would readily constitute the suggestion of possible misconduct. Another response from the government on this question of whether we could have a review on the basis of investigating conduct and misconduct. Another response from the government has been to point to the Thompson court case and say that Justice Brett didn't find misconduct. However, that was not the focus of Justice Brett's deliberations. In the context of the Thompson court case, Justice Brett was not tasked with investigating possible misconduct. He did not take evidence from all relevant TASPOL staff who were involved in the surveillance activities. He did not review all documentation and records of that activity. There would not have been an expectation that Justice Brett would make a finding of misconduct. He was making a ruling on the Thompson matter. However, we can look to his comments in that ruling and what they may point to in relation to possible misconduct. Justice Brett did find at paragraph 8 that the invalidity of the warrant occurred, and he was referring to the wrong section being cited from the Criminal Code, occurred because of carelessness and did not amount to deliberate or even reckless conduct. But His Honour did state that whilst demonstrating a degree of carelessness, the mistake was inadvertent. But beyond that, Justice Brett did express concerns about the nature of some of the contents of the relevant police officer's affidavit in relation to information provided by the police to the magistrate, as to the extent to which the privacy of any person was likely to be affected. Justice Brett referred to that relevant affidavit in his ruling. His Honour quoted from paragraphs 18 and 19 of the affidavit. And that affidavit, in paragraph 18, stated that the privacy of... I'll just extract a small sentence out of that paragraph 18. Having regard to those matters, the privacy of persons other than the named person would not be unduly interfered with. And in paragraph 19 speaks about the fact that police will be able to isolate the monitoring of any listen devices relevant to the particular investigation. It speaks about police not intending to monitor visits that obviously only relate to professional legal visits. Those are the statements that were put in the affidavit to the magistrate, and Justice Brett was concerned about that. Justice Brett commented that the constable had prior knowledge of the relevant... His Honour found, that the magistrate would have been completely justified in accepting the constable's assurances that he would have prior notice of any such meetings and be able to restrict the monitoring of the visits to the relevant investigations. However, we know what played out, that wasn't the case. Justice Brett went on then in his rulings to highlight a number of concerns about that. At paragraph 31, and I'll just extract one part of that paragraph, he finishes that paragraph saying the fact that the magistrate was not told about this and the police in any event did not implement those measures is a matter of significant concern. He also said in paragraph 32, given the real risks to the privacy arising from the near certainty that unrelated private and privileged conversations would be recorded and capable of being monitored during the life of the warrant, far greater detail should have been provided to and considered by the magistrate before issuing the warrant. And he went on, Mr President, over a number of paragraphs highlighting these concerns. I believe it may be open to argument that the constable and his supervisors did not display necessary care and diligence in the course of their duties given the content of that affidavit and the Justice Brett's comments about the fact that there was a casual and incomplete approach to the matter. A criminal prosecution in the Supreme Court was unable to proceed due to the serious but inadvertent defect of the warrant and due to the lack of sufficient care and properly informing the magistrate of the proper operation of the system of surveillance and the casual and incomplete approach to the identification and minimisation of risks to privacy. I believe that it could be argued, therefore, that such police behaviour was a prima facie breach of the Police Code of Conduct and therefore possible misconduct under the Integrity Commission Act and therefore able to be dealt with potentially under an investigation within the current Act.
While the honourable member's just pausing there, I'd like to welcome to the chamber students from Rosny College, the Legal Studies 3 group. Currently we're working through the second reading stage of the Police Power Surveillance Devices Amendment Bill 2022. The bill has been through the process in the House of Assembly and it comes now to the Legislative Council where honourable members of the Council get the opportunity to work through the bill. In the second reading speech, it's whether they have in principle support for the bill. Following that, if it gets into the committee stage, then it's scrutinised clause by clause, and if it gets through that, then it goes on to the Governor to be signed off and becomes an act. And it's good that you're doing legal studies, and this is probably a really good one for you to sit in and listen to today. And all honourable members will make their contributions after the honourable member for Nelson concludes hers, and I'm sure all honourable members will join with me in making you welcome to the Legislative Council today.
Hear, hear. Thank you, Mr. President. So I believe that Section 33(4)(d) provides an opportunity to conduct an investigation right now without amendment to the Act and without having to expand the way that protected information can be used without thorough consideration of intended and unintended consequences. One of the matters that I'm interested in that I also don't see necessarily covered by the O'Farrell review terms of reference relates to the report that's required under Section 29 in the Act back to the issuing magistrate. In regards to the warrant in the Jeff Thompson matter, Section 29 of the Act required the relevant constable who applied for the warrant to make a report back to the magistrate who issued the warrant. The Section 29 report is a mandatory condition of a surveillance device warrant and requires a report back to the Supreme Court or magistrate within the time stated in the warrant. Section 29 of the Act states that the report back to the magistrate must state, and I quote, "the name, if known, of any persons whose conversations or activities were overheard, recorded, monitored, listened to or observed by the use of the device." The mandatory Section 29 report to the magistrate is another avenue that may well indicate if there has been any misconduct in this matter. The Section 29 report here will be critical to the proper investigation of this matter. If provided, it should assist in the identification of those affected lawyers and clients who may have been subject to surveillance inadvertently during the use of these devices in the prison, and who I believe should be advised that their meetings were recorded. There's no mention of including this sort of document in the terms of reference for the O'Farrell review. Another issue that concerns me, Mr. President, in relation to what's proposed in the amendments in the bill before us is that I don't see what I would think we would expect in terms of checks and balances when we are essentially expanding the way protected information can be used. I don't see that there is an obligation to record or disclose to the inspection entity or in annual reports, for instance, instances in which the Commissioner has provided access to protected information under this amendment. I wanted to point to the fact that I don't see particular parameters being provided around providing guidance on how the discretion that's available there to the Commissioner can be exercised. I don't see that we have gone down the path that other jurisdictions have in terms of putting some checks and balances around discretion on very similar matters. And I do note that Section 40 of the New South Wales Surveillance Devices Act, which covers a similar thing, giving discretion to the Commissioner, says this. It's Section 40(6), and it says a Chief Officer may consent to the communication of protected information under subsection 5 only if satisfied that it is necessary or desirable in the public interest, or for the protected information to be communicated to the person concerned, and that the public interest in communicating the information outweighs any intrusion on the privacy of the person to whom it relates or of any other person who may be affected by its communication. So it's there, quite simply, Mr. President, a straightforward check and balance that public interest must be specifically considered when making that decision. We haven't provided for that in these amendments, and that's a concern to me. So where to from here? In the first instance, what's not clear to me that will occur is that any lawyer engaging in criminal defence work in this city or in the state will be able to be rest assured and put their apprehensions aside about potential undisclosed recordings of privileged conversations being in the hands of at least one or more Tas police officers. As Justice Brett noted, only a couple of officers gave evidence before him, not the full complement of 10 officers who had access to the recordings. Absent of a full and transparent inquiry, which isn't what's proposed in the O'Farrell review, we cannot be confident that there has not been improper use of any portion of those recordings or that there will not be improper use in the future. The proposed limited scope O'Farrell review under its terms of reference will not provide that confidence to us. Any lawyer who visited a prisoner during the period of these unlawful recordings is entitled, I believe, to a written statement. And it's been suggested that that written statement should be as to whether their conference with the prisoner was monitored, listened to or recorded, and if so, whether any recordings were made or whether those recordings are stored. Any copy or transcript or notes that were made of that recording. Any documentary records that were prepared from the audio or visual records. If documentary records were prepared, by whom, when and for what purpose. Any recording or recordings that were destroyed. If so, when and by whom, and the records of the destruction which were made and kept. If the recordings are still in existence, then they will be destroyed, then when they will be destroyed and by whom. That should include that the Police Commissioner makes a written apology for her officers improperly recording privileged conversations when the issuing magistrate was not properly informed that there was no proper legal basis to do so. And there was no proper legal basis to do so. And finally, that written policy and practical training has been given or is being prepared to all TASPOL officers to prevent this happening again. I wonder, and I would hope, that such communications to lawyers affected is or has been prepared. Mr President, in conclusion, there are clear questions, I believe, over the interpretation as to the status of unlawfully recorded conversations in the Thompson matter and the potential that the legally privileged conversations were also recorded under that invalid warrant. The question is whether they are protected information as they were unlawfully obtained. This also raises serious and potentially ongoing issues, I think, for our Act, because if we do deem unlawfully obtained surveillance material to be protected information, then we run into trouble, I think, at section 33(4)(a) in regards to whether any of that material recorded has been or may be used in an investigation of a relevant offence. If the illegal recordings are not protected information, they cannot be disclosed to Mr O'Farrell or read or used by him, even with the amendment proposed in this Act. The current amendment to the bill then would not be fit for purpose. This compounds the fact that the proposed O'Farrell review is also not fit for purpose. It's not a comprehensive, appropriately independent investigation of all aspects of this matter, sufficient to deliver confidence to the Tasmanian public. An independent and comprehensive investigation and inquiry is what is required. The current bill, Mr President, I believe, should be given much greater consideration before we are asked to vote on it in this place. I think we need more information here and more demonstration that consideration of some of these matters I've raised have been provided. I think if that is not something that can be provided to us readily here today, then we would have no choice but to vote this bill down and ask for the government to go back to the drawing board and come back to us with full information and a properly considered, appropriately revised approach to a comprehensive independent review of this matter. Alternatively, potentially a review could be conducted pursuant of the existing Act, absent of the amendments proposed in this bill. Again, we could vote the bill down and that avenue would still be available there to the government. So I would invite members to seriously consider whether they feel that there is sufficient confidence that these amendments, which do provide avenues for less privacy available to people who have been surveilled, whether they are warranted, whether they have been given proper consideration and full consideration of intended and unintended consequences. We are changing an Act with these amendments permanently, not just for the O'Farrell review and the convenience of potentially conducting that more readily, but for all many other uses that may then come into play under the amendments made. I would hope that we might not deal with this today. I would appreciate the opportunity to hear more in more detail, not just in the Leader's summing up, which will be limited in the scope that it's able to provide, given that I'm sure the intention will be to address matters. I don't believe that I'll be in a position to support this bill with information that can be provided on the fly today. And In the absence of that, I will have no option but to vote against the bill. However, I will reserve the right to not vote against the bill if we actually were to have an opportunity to have more detailed briefings and address these issues in more detail outside the chamber before we come to a vote. Thank you, members. I realise that was a lengthy contribution on the bill, but I wanted to, it's one I think is really important, matters to do with rights, matters to do with protecting the privacy of citizens, should never be taken lightly. And I feel that overall, in relation to the surveillance issues around the Jeff Thompson case, and then what's flowed from that with the proposal of the Farrell review, and then seamlessly going into amending an act in order to facilitate it, is simply not good enough when it comes to robustly considering with a clear mind before we look to potentially erode privacy protections. I invite members to hopefully have a better opportunity to get more information, or if not, if we go to a vote on this bill today, I invite you to vote the bill down. It doesn't mean that the government can't go back and try again with another consideration.
Question is that the bill be now read the second time. The Honourable